People who are perfectly happy selling away their liberty for a little bit of supposed security. And gentlemen, just recently the Supreme Court decided a case. It's United States versus Jones. A man had a GPS device attached to his vehicle without a warrant, and he sued, and he won. Not surprisingly, the Hussein Obama administration was defending this in court. They wanted the ability to attach a GPS device to your vehicle without a warrant. And as I've mentioned many times, this is an about-face from his campaign rhetoric. This wasn't related directly to the Patriot Act, but it's part of what I call the Patriot Act culture. On the central question in the case, the government argued the following: attaching a GPS tracking device to a respondent's vehicle was not a search or seizure under the Fourth Amendment. The government lost, period. Some were trying to throw cold water on this by saying the court declined to reach when the installation of the device is reasonable or unreasonable, so we actually don't yet know if a warrant is required to install a GPS device. We just know that the installation of the device is a Fourth Amendment search. Does the search caused by installing a GPS device require a warrant? The answer may be no, given that no member of the court squarely concludes it does, and 4 members of the court, those who join the Alito concurrence, do not believe it constitutes a search at all. Here's the pushback. It's true that the court's majority opinion didn't explicitly find that the search that occurs when attaching and using a GPS device requires a warrant, but look at its characterization of the opinion it affirmed. The United States Court, quote, the United States Court of Appeals for the District of Columbia reversed Jones's conviction because of admission of the evidence obtained by a warrantless use of a GPS device, which, it said, violated the Fourth Amendment. The court did decline to consider the argument that the government might be able to attach a device based on reasonable suspicion or probable cause. That argument was forfeited by the government's failure to raise it in the lower courts. But if the Supreme Court were limiting its holding to the attachment as search issue, it would have remanded the case back to the lower courts for further proceedings consistent with the opinion. It did not. And the sensible inference to draw from that is that the general rule applies. A warrant is required in the absence of one of the customary exceptions. Failing to make that explicit was not opening a door to a latent government victory. U.S. versus Jones was a unanimous decision rejecting the government's warrantless use of bizarre technology to defeat the natural privacy protections provided by law and physics. The government physically occupied private property for the purpose of obtaining information when it attached a GPS device to a private vehicle and used it to gather information. This was a search that the government could not conduct without a valid warrant. And this is a huge victory, guys. This is a huge win for civil liberties, for our civil liberties, unless you're an idiot who actually trusts the government to conduct itself accordingly. I don't. Justice Scalia ruled on the relatively narrow grounds that installing the tracking device involved physical intrusion on the suspect's property, triggering Fourth Amendment protections. Yet, as Justices Alito and Sotomayor observe in separate concurrences, there are plenty of means for tracking a target's location in public that don't require such intrusion. One of the most popular with law enforcement is cell phone tracking, either by means of a court order demanding records from the phone company directly, or through the use of devices known as stingrays or triggerfish. There's also a use of license plate recognition cameras and even aerial surveillance drones. A broader question that's crucial to determine the extent of our privacy rights in long term then is the one Scalia's opinion pointedly declines to reach. Does prolonged technologically assisted location surveillance impinge on a citizen's reasonable expectation of privacy, even when it does not require physical intrusion? Justice Alito, joined by 3 other justices, says that it can indeed, and in this case did. The placement of a tiny device on the undercarriage of a car parked in a public place, Alito argues, does not sufficiently interfere with a suspect's property interest to constitute a Fourth Amendment seizure, nor is it a search until police activate and begin monitoring the device. Of course, I could point out, why would they attach a GPS device to your vehicle if they're not going to use it? If the police had simply slipped a business card in the tire, after all, the physical intrusion would be too minor in itself to count as an actionable trespass. Instead, Alito insists it is necessary to proceed to the harder question of whether such intensive location monitoring violates our reasonable social expectations of privacy, even as we move around in public. Though the concurrence is reluctant to say exactly when that expectation is breached, Alito notes that round-the-clock surveillance over a full month would be so costly to carry out by conventional physical observation that it exceeds what reasonable people expect, and so triggers the Fourth Amendment's warrant requirement. I also need to mention, as per usual, all the relevant links will be underneath the video. See the previous the video on your screen currently. I've already gone over the Patriot Act in another video, and this brings in Hussein Obama's hypocrisy on this issue. He campaigned against the Patriot Act, campaigned largely against Bush in 2008 concerning Bush's intrusion on our civil liberties, and then did an about-face and has reauthorized the Patriot Act and even gone further than Bush. I've also exposed Obama in other videos. See my Obama versus Obama playlist. But as far as the Patriot Act, Obama has done a complete about-face on that. So I have to ask these leftists and civil libertarians who voted for Obama, if you're going to be honest with yourself, you'll have to vote. You'll have to either get to, if you live in Florida, you can get to their primary on the 31st and vote for Ron Paul, or you can sit it out, which I wouldn't recommend. I always participate. Vote for a third-party candidate. But if that was one of your bigger issues, well, you're going to lose that talking point if you vote for Obama again. So I'd say all those civil libertarians and Democrats who were angry at Bush for the Patriot Act, Obama's basically disqualified himself from your vote, unless you just used it to get elected, to get him elected as he did. mccainisthrough, who I refuted in that other video, was very adamant that the Patriot Act was illegal and Bush was violating our civil liberties and undermining us. And that was true in large part, but she hasn't said much about it since then. She just used it to get elected. In fact, she doesn't know much about it. In that video, I gave her a little history lesson. She had no idea. She thought Bush and Reagan were the only presidents who had ever engaged in any kind of surveillance. She thought Bush was the first person ever to engage in warrantless wiretapping. Basically, I gave her a little history lesson. She's not educated. But Hussein, as I said, he wants to go even further. He's also wanted to have access to Yahoo's email cloud without a warrant. Now, even though Yahoo's technically a public place, and if you get an ID there and an email address, it's your private email address, but it's still under Yahoo's authority. And they argue because of that, it's kind of public, that they should have access to that without a warrant. Hussein's wanting to do that too. He's also been very clear, his administration, that they want to be able to monitor your cell phone without a warrant. I'm okay with them monitoring anyone's cell phone and intercepting their email as long as they get a warrant first. And we have this, Obama administration monitoring social networking sites. Documents have been uncovered revealing the Department of Homeland Security, run by Janet Napolitano under Hussein's direction, is monitoring dozens of popular websites such as Facebook, Twitter, the Drudge Report, the evil Drudge Report, the Middle East Media Research Institute, and Jihad Watch, and is collecting personally identifiable information. The documents were first uncovered by Reuters and have been confirmed as genuine by Washington officials. A document dated November 15, 2011, entitled Privacy Compliance Review of the NOC Media Monitoring Initiative, explained the program. The government, the document said, monitored publicly available online forums, blogs, public websites, and message boards to collect info used in providing situational awareness and establishing a common operating picture. Included in the information collected, the document confirmed were limited instances of personally identifiable information. The data is used by the DHS and other agencies to harass people. Excuse me, I added that. DHS and other agencies, including the U.S. Secret Service and the Federal Emergency Management Agency, FEMA. The full list of sites included Vimeo, YouTube, and MySpace video. Also on the list are Storm Pulse, Flickr, Twitter API, radio on Twitter, TV on Twitter, Tweet Stats, All Africa, CNO News, Cryptome, Global Security Newswire, Google Blog, Homeland Security Today, Jihad Watch, MEMRI, I don't know what that's an acronym for, MS-13 News, Plowshares Fund, Stratfor, Science Daily, and dozens of others. So we have this Patriot Act culture is leading to a bit of a surveillance state, don't you say? Unless you've totally got your head in the sand and you're very optimistic. Lastly, Newt Gingrich said this about the Patriot Act in an exchange with Ron Paul. Newt made it clear he wasn't going to make any changes to the Patriot Act despite evidence that the government is trying to abuse its power and can't even follow its own rules. See the video I had on your screen earlier for government abuses of the Patriot Act. Newt said, and listen to this closely, Newt said, the key distinction for the American people to recognize is the difference between national security requirements and criminal law requirements. He didn't say whether this pertains to American citizens or not. The key distinction for the American people to recognize is the difference between national security requirements and criminal law requirements. I think it's desperately important that we preserve your right to be innocent until proven guilty if it's a matter of criminal law. But if you're trying to find someone who may have a nuclear weapon that they're trying to bring into an American city, I think you want to use every tool that you can possibly use to gather the intelligence. The Patriot Act has clearly been a key part of that, end quote. Do you notice the distinction he made between criminal law and national security? So if my friend Larry, he's an American citizen, what the police use to prosecute him should be really no different if he's charged with burglary or taking sides with Al-Qaeda. Granted, taking sides with Al-Qaeda is far worse, but if my friend Larry's an American citizen, he is given those rights. The only way the government can suspend habeas corpus is in the event of an insurrection or rebellion. Now, if you've got an isolated lone wolf incident with my friend Larry, the prosecution of his case should be no different if he's charged with burglary or throwing in with Al-Qaeda. He is still innocent until proven guilty. You still need a warrant. You know, there's certain exceptions like hot pursuit. But Newt's trying to, and you see how they're going to do this. If they think you're a terrorist, what they're going to do is waive certain rights you have. And they've already been trying to do that. We've got smoking gun evidence that they're abusing the living hell out of this. So if it's a criminal law trial, yeah, you're innocent until proven guilty, yada, 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 we'll charge you with a crime. But Newt's view here is a slippery slope, which will lead to the government, if you're a terrorist, supposed terrorist, and it's a national security issue, they can waive those rights. They can hold you without trial. They can't do that if you're an American citizen. So Newt Gingrich's view right there is going to lead us directly to a police state. And I hope enough of you people realize that before it occurs. Otherwise, I'll just say I told you so. Have a nice day.